Serial number 36, the Commissioner versus Sri Niranjan Prabhu. For the listeners, we should have to start.
Lordships, this is a case where for sexual harassment of a student, the teacher was proceeded against, Your Lordships. Now, the matter came up before the Central Administrative Tribunal, Your Lordships. The administrative member upheld the order of the disciplinary authority. The judicial member disagreed. Matter was referred to the third member. Your Lordships, I be permitted to just place the order of the third member. That is para 11 onwards. That gives the gist of the whole case, Your Lordships. Internal page 9, Your Lordship, of the order. Before I proceed further, I fully agree with both the honourable members of the bench with respect to the conclusion that the Commissioner NVS, the highest authority in the management of the institution, has concluded that the regular inquiry needs to be dispensed with for the reasons recorded by him in support of his decision with respect to not to conduct an inquiry under the rules and also post the facts before the Minister, Human Resource Department, Government of India in that behalf. Without hesitation, no fault can be attributed to the respondents with respect to the dispensing of the full-fledged inquiry. Now here I will pause, Your Lordships, and submit that all three agree on this one point. Your Lordship, then
on the point that no inquiry is required.
Yes, that is under the circular of 1993, Your Lordships. Circular dated, Your Lordships, 2012-1990 circular, which empowers that in cases where it is not appropriate for a full inquiry to be held, where the victim will be cross-examined and things like that, then the inquiry may be dispensed with. And if he is prima facie found to have committed the offence, he can be punished. And that has been upheld by the Honorable Supreme Court.
Then the petitioners have followed which procedure?
They have followed that procedure laid down in the 2012-1993 circular, Your Lordship.
Whichever act, some act is there, no?
Act is...
Sexual Harassment Act.
That act is there, but for the Navodaya Vidyalaya Samiti...
No, these employees are governed by which rules? Regulation.
By the CCS rules, Your Lordship.
CCA.
Yes.
CCA rules. Rule 14.3.
Lordships.
How do you overcome?
Your Lordships...
TGT.
Yeah?
TGT. Trained graduate teacher.
He is a trained graduate teacher, Your Lordships.
Rule 14.3C, something has been incorporated. With respect of sexual harassment matters.
Your Lordships, Your Lordships, at page 7 is the notification, Your Lordship. Annexure 15. It says it has further been decided with the approval of the executive committee that the relevant...
No, rule, have you seen it? Seen the rule?
Just getting the book, Your Lordship.
Read 14.2. Provide proviso. Up to date rules.
Yes. 14.3. Where it is proposed to hold an inquiry against.
No, that is not the, provided that where there is a complaint of sexual harassment within the meaning of Rule 3C of the Central Civil Conduct Rules. The complaints committee established on each ministry or department or office for inquiring into such complaints shall be deemed to be the inquiring authority appointed by the disciplinary authority for the purpose of these rules, and the complaints committee shall hold, if a separate procedure has not been prescribed for the complaints committee for holding the inquiry into the complaints of sexual harassment, the inquiry as far as practicable in accordance with the procedure laid down in these rules.
Your Lordships. Your Lordships, I think.
One more rule is there, dispensation. I don't know whether you have that provision or not. In the very same CCA rules, there is a provision. Are you sure that this Navodaya employees are bound by this CCA rule?
That we have stated on affidavit also.
This other notification is prior to Vishakha case.
One thing that I am lacking here, that which Lordship allow me to permit. Written statement filed before the learned tribunal. On the basis the learned tribunal has disposed of the original application. Is not on part of record. Summary trial was conducted. Summary trial was conducted. Summary report came. The matter was placed before the competent authority commissioner. Commissioner, while ordered at the last page of the written statement, 21st December 17, turned down the report, trial committee report, directed them to re-inquiry. No re-inquiry was conducted.
Your Lordships, may just permit me to complete the impugned order, Your Lordships.
No, further, where is the provision for dispensation of inquiry?
Your Lordships, that is the 1993 rule.
No, 1993 circular, you said.
Circular, sorry.
Circular will not override rule. Rule is 14.3C. 14.2 read with conduct rules. Where is the conduct rules? Central government conduct rules. Idhar hai. Separate central government. Central Civil Services within the conduct rules 1964.
का केस है.
Proviso to Rule 14.2,
Your Lordship.
you are required to comply this rule only, provided if you have any other procedure rules.
Your Lordships, what they have done, I'm just informing Your Lordships, what they have done is they have followed this notification,
No, what?
upheld by the Supreme Court.
We'll adjourn this matter next week. In the meanwhile, you get instruction whether how do they work the 14.2 proviso. One thing. Another thing is the Sexual Harassment Act has came, whether that has been adopted by the central government or not.
That I'll take it.
If this, that has been adopted, then you can dispense inquiry under this and you can follow that procedure laid down therein.
Notification.
And the act read with the rules. They have also framed rules.
Yes. But in that also, Your Lordship, the appeal is provided as per CCS. But Your Lordship, I was going to Your Lordship make another submission. Seeing this, Your Lordships, I don't know if Your Lordships would consider it appropriate to remit the matter back
For what purpose?
for them to inquire afresh.
Huh?
For them to go into it afresh. Because if Your Lordship sees para 17 of the third member,
This is the order.
that is
the order by the learned tribunal.
that is the order of the learned tribunal, paragraph 17. If Your Lordship sees, Your Lordships may like to consider it. And that may end this in view of the above observations, I agree with the view taken by the Honorable Member J. However, to cure the
So
deficit,
this from the stage of summary trial is held under which provision?
summary trial is held under that 93 notification, which has been upheld by the Supreme Court.
93 order will not override this rule.
That I understand, Your Lord, because this is a later amendment.
That's the reason you get instruction.
I'll get it.
Let us not have confusion.
Instructions on 2 counts, whether the
14.2 proviso is required to be has been complied or not. One thing. Second thing is Sexual Harassment Act so and so and read with rules have been adopted by the central government while amending CCA rules.
Your Lordship may give 2 weeks.
Instant writ petition is by the Union of India dash Navodaya
Vidyalaya Samiti.
huh?
Navodaya Vidyalaya Samiti.
Navodaya Vidyalaya Samiti. Twist of respondent was subjected to some inquiry on the allegation that he was alleged to have involved in some sexual harassment to a girl student. So, resulted in termination service, and it was subject matter of litigation before the CAD. So, learn counsel for the is hereby directed to apprise this court as to was there any compliance proviso to sub rule 2 of rule 14 of CCS within bracket CCA rules 1965 or not. Further, in the light of so and so act, Sexual Harassment Act, so and so, read with the rules read therein have been adopted by the central government or petitioner Navodaya so and so Samiti or not, in order to examine whether the petitioners have followed the relevant rules and regulations or not. This matter after 2 weeks.
All right.